Everyone, please be seated. Thank you for joining us today. We have 4 cases that are set for this morning. 2 of them are oral argument, 2 of them without. The case of State of Iowa versus Iowa District Court for Woodbury County is hereby submitted without oral argument. And the case of William Lee Pitts and Lynn Pitts versus United States Cellular Operating Company of Dubuque is also submitted at this time without oral argument. Before we begin our first case, I do want to acknowledge we have a group of kids here from the Marshalltown High School. Raise your hand, Marshalltown. Thank you for being here. We all have, of course, at least a high school degree, and we have a little bit beyond that, but I like to bring it home to you guys and let you know how important that is. We're going to go in order of seniority from my right to my left, back and forth, and we're going to tell you where we graduated from. Some people get a little bit excited about their school, and they say more than they're supposed to, but like I'm going to about right now. I'm from Harlan, state football champions this year.
High school, class of 77. And Tom Waterman is my name.
I'm an Iowan by choice, which means I went to high school out of this state at Lexington High School in Lexington, Massachusetts, class of 1974.
Christopher McDonald, Des Moines Lincoln High School, class of 92.
Dana Oxley, I went to school at Greenfield High School, which is now Nottoway Valley.
And Matt McDermott, I went to Kemper Catholic in Carroll, class of 96.
I didn't mention my name. I'm Susie Christensen. Thank you for being here. All right, our first case set for oral argument is Environmental Law and Policy Center, Iowa Environmental Council, and Sierra Club versus the Iowa Utilities Board and MidAmerican Energy. Looks like the parties are ready, and I believe I understand Joshua Mandelbaum will speak first. Thank you.
May it please the court, I'm Josh Mandelbaum, and I'm here on behalf of the Environmental Law and Policy Center, Iowa Environmental Council, and Sierra Club. And by the way, I'm a Des Moines Roosevelt High School graduate.
To say it too when it's your turn.
The Iowa Utilities Board erred as a matter of law in creating a novel interpretation of Iowa Code Section 476.6, Subpart 19, the Emission Plan and Budget Statute. The board excluded compliance options from the scope of the statute unless presented by the utility, and therefore avoided consideration of the environmental parties' evidence in MidAmerican Energy Company's 2020 emission plan and budget filing. In my time this morning, I'm going to provide some brief background on the emission plan and budget dockets. I'm going to address how the board's new statutory interpretation is inconsistent with principles of statutory construction and creates a statute that means one thing for the utilities and something different for every other party. And third, I'll address how that interpretation is inconsistent with past board practice and decisions in other emission plan and budget dockets. Coal-fired power plants must comply with stringent federal ambient air quality standards and state regulations. These regulations include but are not limited to particulate matter, ozone, sulfur dioxide, nitrogen dioxide, lead, interstate pollution, mercury, and regional haze. In multiple past emission plan and budget dockets, MidAmerican Energy, Interstate Power and Light, and environmental parties have introduced evidence of various compliance options, including coal plant retirements. In those dockets, those retirement options were within the scope of the statute. In fact, MidAmerican, in previous dockets, provided plans where cost-effective compliance with the statute included retirement of the coal plants.
Were any of those dockets, or which one of those dockets contained retirement as an option that was presented by someone other than the utility?
So in the 2016 Interstate Power and Light docket, the environmental parties provided testimony that other compliance options should be considered, including comparing to coal plant retirements and gas conversion. And so we had witness testimony in that 2016 docket.
Power and Light had not considered retirement as one of their proposals in their own budget report, right?
In their initial, but they did provide supplemental testimony where they did consider alternatives and provided a record in that manner.
Statute ambiguous, and if so, what specific language?
So the statute, obviously there are different interpretations of the statute from the parties, so that implies some ambiguity. We focus on managing regulated emissions and what the term managing regulated emissions means in the context of the statute. And context is important. This court has generally presumed that the terms in the statute have their ordinary meaning and are used in the usual sense. And that's certainly the case here.
Of management, or to manage, to me doesn't necessarily imply shutting it down, does it?
That's where context is important, because manage in the ordinary sense, it's to accomplish something or to control, and it's looking at what you are trying to accomplish in this case. And the statute provides guidance in that regard, and what is trying to be accomplished is compliance with state and federal requirements. And compliance with state and federal requirements is a range of options. It's not limited to just one option. There are multiple options that comply with state and federal requirements.
I know it's your position that the board erred in not considering the alternative plan that was proposed. But is it your position that the board is required to select the most cost-effective plan or the least cost alternative?
That is not our position. The board is required to consider the evidence, and the statute provides guidance on how the board weighs that evidence.
The harm in this particular case, let's say we agree the board erred, at least by breaking with its precedents of considering this kind of evidence. Considering that they established another docket, what's the harm in the case?
So there are two harms. One, let me address briefly the other docket. And that other docket did not actually fulfill the purpose that the board set out. That other docket was closed without looking at a comprehensive plan and without comparing generation options and forward-looking planning, as was intended. So there's a harm there. But the statute requires a balancing. So the statute requires cost-effective compliance and balancing cost, environmental requirement, economic development potential, and the reliability of the electric and generating and transmission system. And that comparison didn't happen. That balancing did not happen. You can't have that balance without environmental parties' evidence and looking at the coal plant retirement as an option that could provide a better balance and a more cost-effective option.
What deference do we owe the board in doing that balancing? I mean, isn't there sort of some level of discretion that the board should have in juggling the different factors that it's supposed to under the statute?
Certainly, and that goes to weighing the evidence, and the board's expertise in weighing the evidence certainly would require deference. But the board did not even exercise that expertise because the board excluded the evidence. And in doing so, the board interpreted the scope of the statute, which there the board does not get deference under this court's precedents. There's a long line that the board generally does not defer to, or the court rather, does not defer to the board in terms of the scope of the statute, from the Nextera case, where the board didn't on, or the court didn't on electric supply needs, to SC Enterprises, where the court didn't defer to the board's interpretation on electric utility and public utility.
Isn't the argument here somewhat that the evidence that you've put in, the board didn't take on? Couldn't that argument sort of always be made, that there's some additional info that the board didn't take up? I mean, at some point, isn't there sort of enough, kind of a threshold of information that's met, at which point we'll say, okay, that's enough, the board has discretion in sort of weighing kind of that critical mass, whatever it is?
Certainly, but look at this case. And by statute, this is a contested case proceeding. And a party in the contested case proceeding presented evidence. That's part of what the board must weigh, is evidence within the scope of the statute, relevant evidence by that party. Now, they can give weight to the evidence that we might not be happy with, but in a contested case proceeding, the board should hear the evidence and make a determination based on that evidence.
Wait, or can we infer, you have this kind of repeated process, right, of biennial filings. The board is an expert in considering these matters. They've dealt with MidAmerica since 2020, and I guess there have been at least 10 reports since then. Shouldn't we put some weight on the fact that the board understands the issues? They've dealt with retirements before. They can evaluate the evidence that was presented on the cost effectiveness of this particular plan. Even though they didn't explicitly consider your evidence, we know that they understand it because they've looked at it in the past. Why can't we credit them in that sense?
Again, the evidence needs to be considered in this docket. And what the board is doing in this particular docket is varying from precedent. This docket is the outlier where they're not considering evidence. So in MidAmerican's 2014 plan, MidAmerican explicitly said, MidAmerican assessed the cost of its compliance for units not currently scheduled to have controls installed. And MidAmerican determined that based on economic and other considerations, it's in the best interest of customers to comply with MATS, the mercury and air toxin standards, and other environmental requirements by discontinuing the utilization of coal as a fuel and not installing environmental controls on 5 units. Now, if what the board is doing is essentially creating a statute where the utility controls the scope of the statute, and the utility controls, the monopoly utility, controls what evidence is considered and evaluated by the board and the parties.
You contemplate that to some extent. It says that the purpose of the statute shall be achieved through, quote, a collaborative effort involving state agencies and affected generation owners. So it seems like the statute contemplates the fact that this would involve the IDNR, OCA, the utility, and that's really the most relevant parties here. And as long as they're all satisfied that the plan is okay, then it says the board shall approve it.
The utility sets the stage, right? So obviously the utility plan is important. It sets the stage. It's what DNR reacts to. It's what the other parties react to. But the utility plan is not the full breadth of what is considered. It's still a contested case. And under Iowa Code 17A12, subpart 4, parties in a contested case, which includes environmental parties here, have an opportunity to be heard and to present evidence on all issues. And that is what environmental parties were denied here when our evidence was excluded purely as outside the scope of the statute.
Who's doing the contesting? It seems almost more like an ex parte hearing.
I mean, environmental and the practice in front of the board is to bring in stakeholders. There's a standard for intervention, and parties must meet that standard. There are public groups that have an interest, whether that be a consumer advocate, which has an interest that's sufficiently important that that they are written into statute to be a participant, but the statute contemplates that there are other interests to be represented, including environmental interests. And this is a statute that is focused exclusively on environmental pollution. This is a statute that focuses on coal plant emissions. And it was important enough to merit its own section in the code, important enough to merit bringing in the Department of Natural Resources to ensure that state and federal requirements are followed. So in environmental parties, the board recognized, and it's not at issue in this case, that environmental parties have an interest and were properly admitted interveners in this docket. So as parties to that, environmental interveners submitted evidence, and that evidence wasn't considered. Instead, what the board did, it did not give meaning to the entire statute. Again, that key piece, the state and federal managing emissions to meet state and federal requirements, the board set a different limiting principle, not those state and federal requirements, but what the utility submits as part of its plan. And that also impacts the ability to affect the cost effectiveness balance. And that's the statutory purpose here, right? When you reference the collaborative process, the other piece of that statutory purpose is to balance environmental requirements with energy policy. And that focuses on the cost effectiveness. And that balance is cost, environmental requirements, economic development potential, and the reliability of the system. And to get that optimum result for expenditure, there's a comparison involved. And if the utility doesn't need to make that, when other parties present evidence that there is a better way to get that balance, a better way to meet the goals of the statute, that is something that the board should consider and weigh and apply its expertise to. And that did not happen here, and with the board's interpretation would not happen unless the utility says it should happen.
Remedy here, in this case, if you were right.
So the remedy is to reverse and remand back to the board for further proceedings.
Practical consequence of that. So the next biennial filing, if I understand it, is coming up this January 2024. Is that right? We would remand this to the agency to consider the evidence. If I understand it right, they would have 180 days or 6 months from that time to consider it. So they're going to approve a plan, let's say, late this year, November, December, and then have to start over again with a new plan in January of 2024, right? So why would we do that? What's the practical purpose for doing that?
So the practical purpose, again, there was evidence that wasn't considered and heard, but the board gives advanced review or approves a plan. And so the costs that have been incurred consistent with that plan, in theory, can't be challenged in future cases, whether that be a rate case or not. And so going back and addressing that relative to the past plans has an impact on the operation and maintenance costs that are incurred relative to those past plans, and so is relevant in that regard and important in that manner. It also will set the precedent for future plans and what the scope is of those future plans. Right? And so if it certainly could be addressed on an ongoing basis going forward, and you potentially the board could incorporate these issues together.
I need to study the law in the case, but as a practical matter, I have to say I'm somewhat puzzled by the position taken by the board in MidAmerica. I mean, what's the harm in allowing your clients to present evidence that there might be a more cost-effective or more efficient way to achieve these environmental requirements by retiring a coal plant, which obviously coal is sort of the worst contributor to climate change. I mean, I just don't understand. What's going on practically that they don't want to hear from you? Can you, if you know?
That's hard to speculate. I mean, I think on the record below, and the board was in a position where this again was different than other cases. We presented evidence, and not only did we presented more than testimony, we went out and got an expert who did modeling and economic analysis and included that evidence in the record, which was a step beyond what we had done in that 2016 IPL case where we didn't meet the threshold in terms of weighing the evidence. So we had a better evidentiary record than we had had in previous dockets. And the utility, unlike in that 2016 case where the utility rebutted our evidence, the utility was silent on it and made an argument that it was outside the scope. And so the record below wasn't perhaps flushed out to lead to a result if you weighed the evidence. MidAmerica hadn't created sufficient evidence to perhaps weigh, and that was maybe a problem for the board in resolving the issue.
The board weighed your evidence and the plan that you presented and said that MidAmerica's plan apparently was not cost-effective in light of that. MidAmerica then would have had to do a completely different plan? That plan would have been rejected and then would have had to come up with a completely new one?
That plan would not be approved, and so those costs that were part of implementing that plan would not be pre-approved, so the MidAmerica could submit another plan or would deal with the consequences of those costs not being pre-approved by the board and subject to further review in a rate case and maybe an inability to recover those costs in the future.
So it's not necessarily that MidAmerica has to go with the most cost-effective plan, it's just that it affects their ability to pass those costs on.
Right, and cost-effective, again, the cost-effectiveness balances multiple. So it's not just a cost piece, it's cost-effective in the context of balancing costs, environmental requirements, which is a big part of what the statute is about, but also economic development and reliability. All those things need to be presented and weighed as part of the board's consideration.
The question of harm. So the Administrative Procedure Act says that a party has to be injuriously affected before the court can provide any relief. How are the environmental parties specifically, as opposed to consumers, let's say, how are they injuriously affected by the board's decision?
So if the board doesn't act and meet these environmental requirements in the most cost-effective way, and in this case, in a way that reduces pollution even more, so the balance is it's both cost-effective, less costly in our contention, as well as more environmentally protective to retire these coal plants, the public is getting unnecessary pollution as a result of
Harm to your clients distinct from claimed harm to the public generally?
well, again, our clients are in these dockets representing the public interest. And the harm to our clients, again, as groups that care about and are working to reduce pollution, there is greater pollution as a result of the board's error in this case and not pursuing this. And I see I'm out of time, and I'll be back up for my reply.
And tell us where you went to high school.
Thank you. Good morning. Diana Maker, representing the Iowa Utilities Board. And I did go to Des Moines East High School, so I'm a native here. May it please the court, before addressing the merits, I'd like to make a brief point on the standard of review on the interpretation of Section 476.619. Based on your established principle, the board is entitled to deference here when you examine all the provisions, their context, and see that the board's duty is to engage in a very specialized analysis of substantive terms for the purpose of determining compliance in a very technical area. And
Let me step in there. I mean, cost effective, that's not a word that's limited to utilities. That's kind of a general principle of economics or daily life, right?
agree with that.
That's certainly not something that's limited right? I mean, I agree with the proposition, and I think Mr. Mandelbaum agrees with the proposition that the word reasonably gives some wiggle room to the board in terms of it doesn't have to approve a perfect solution. It just has to approve one that's a reasonably good solution. But in terms of what the words themselves mean, they seem like common words that to which we don't give deference to the board. Am I missing something there?
Agree with you, Justice Manfield, and in fact, you had addressed in your dissent in the SC Enterprises about the combination of ordinary words or words capable of an independent legal definition that was mixed in with highly technical terms. Because if you go on in paragraph C, the board is given discretion or leeway, if you will, to weigh substantive criteria. And if you look further in paragraph F, the board is actually given discretion to limit capital investments and expenditures. And so I agree that there are particular terms that are capable of independent legal definitions and may even be used elsewhere in other code provisions, but nonetheless, they are mixed in and intertwined with substantive terms that are within the board's special expertise. And I would add, just as
Follow up on that. It seems like that's a different argument than the Renda case that you're relying on. I think what Renda says is that if there's a very technical term that needs interpretation, then the courts will defer to the agency's interpretation of that term. What you're saying is that there's not a term here that is technical. We should just defer to the board's application of law to the facts or its conclusions, which is already provided for by statute. I mean, that's not a Renda issue. That's a standard of review issue on application of law to fact, to which the board is entitled to deference for that.
And I would agree with that, but then also add where there has to be a balancing of criteria, substantive criteria, and that gives the board discretion and the leeway that was talked about in the Putney decision. And for
Just to keep going down this track a little bit, Mr. Mandelbaum talked about how the issue here isn't exactly weighing the evidence. It's the required info that goes into this mix to balance it. And 476.6 puts in place a contested case, and we have parties that have properly intervened here, and they have put on evidence, and it would appear that the board hasn't considered that evidence. And so the question is, I guess, why not? I mean, why not do what Mr. Mandelbaum is saying? If you don't think it's worth anything, then weigh it low, but to simply strike it and to say you're not going to look at it at all in a contested case where a properly intervened party has put on evidence seems problematic, doesn't it?
Oh, and no, the board was correct in determining that that particular information, based on an erroneous interpretation of the statute requiring consideration of alternative options, was outside the scope of the proceeding for various reasons. And I'd point out, for one, the board had never required that the utility provide a comparison.
Said, what is outside the scope of the proceeding?
Well, the consideration of alternative options is contrary to the plain reading of the statute and its scope and purpose.
Where? What language?
The statute requires that there is cost-effective compliance, and the appellants have read into their least cost-effective compliance.
Cost-effective still, doesn't mean the most cost-effective, but it does imply some kind of comparison, doesn't it? I mean, if you can't make any comparison at all, how do you know whether something's cost-effective?
If you look in previous dockets and the board's EFS does not go back to the very beginning, to the first plan filed in 2002, but certainly there are other dockets where the board itself had questions as to the cost, any inaccuracy, where the costs were derived. And so certainly there is other information that the other parties could put forward into the proceeding. And also, this particular statutory provisions do not require alternative options to be considered.
Your position is that the other parties can challenge maybe the underlying premise of MidAmerican's proposal, whether or not the costs are accurate and whether, with respect to what they've actually proposed, but they cannot propose alternatives. Is that your position?
Correct. It is.
To your opposing counsel's cite to the 2016 Iowa Power and Light docket where he said that retirement was proposed as an alternate, just their testimony. They didn't actually have a plan, apparently.
And this is contained in our brief as to appellate's characterization of that 2016 docket. The issue was brought up in the MidAmerica EPB proceeding on its update. And there was an issue in the Ottumwa unit where IPL and MidAmerica own that facility jointly. And the appellates had, in that case, raised an issue of cost. MidAmerica had provided the information voluntarily. It was not required by the board, but the parties reached a settlement which the board accepted in that particular case because there was a balance of the four criteria. The statutory requirements were met. And so in the MidAmerica proceeding that was related, the board refused to have a hearing that the appellates requested for further information and accepted the parties' settlement as evidence, in addition to actually a technical expert that had given testimony on the specific control device that was at issue and its cost.
Clarify what you said earlier about scope. So the issue here isn't the retirement of the plant necessarily. It's the board's position that evidence of an alternative plan is outside the scope of the statute.
It's both, if you will. The scope of this.
This is the fact pattern. MidAmerican wanted to put in scrubber X, and the environmental parties intervene and say, we think scrubber Y is better. Is it the board's position that scrubber Y alternative plan is outside the scope of the statute?
I would say when it's requiring consideration of the alternative, then yes, it's outside the scope of the proceeding.
Framed it as, this is not an alternative plan, but we think scrubber X is not cost effective because there is this scrubber Y that is a cheaper alternative. So if they phrase it that way, then it's inside the scope. But if they phrase it as alternative plan, it's outside the scope. Is that what you're saying?
Yes, and there's a couple of reasons. The proceeding, proceeding is very limited in time period.
But why, as a practical matter, if a party says, I have evidence that this isn't cost effective because there's an alternative, its admissibility depends on whether they say, this is a proposed plan or this is evidence of cost effectiveness. And in one case it's admissible, in one case it's not. That's what your position is now?
Two things in the statute that I think support our position, and that is that the statute does not specifically allow for the consideration of other options. It certainly does in other provisions. For instance, in advanced rate making, under Section 476.53, and there's a few other provisions that has been cited by MidAmerica on that particular, those provisions. And second is the statute, these statutory provisions allow for the DNR to make suggested amendments to the plan based on environmental requirements. And if in fact the legislature had intended for other parties to make recommendations on cost options or other alternatives, why wouldn't the legislature had done that and provided that in the statute? That DNR provision is under A4. And also, so you take those two things together.
What is the point of having people who are allowed to intervene as a matter of right if it's not to consider other cost-effective alternatives?
I was very interested in that and looked through all previous dockets that are available. And there was a list of a number of things that the board itself had asked for on cost, on specifications, on pending federal litigation, on environmental requirements, and how MidAmerica would be expected to react and respond to those regulations. There was a question from the board on the accuracy of the numbers that MidAmerica had provided in its cost. I think there was additional information requested by the board as to an economic development question. And so I think those underlying issues as to the 4 criteria that are required to be reasonably balanced, those are what are at issue and limited to cost-effective, not least cost-effective, not the most cost-effective option.
Chief, if I could ask a question while the attorney for the Utilities Board is still at the podium. Why was a separate docket opened, and what happened to that proceeding? And is there any question of mootness?
Could you answer that question? Because I know that was brought up, that why wasn't this important enough to hear or allow them to proceed forward? They were recognized as important issues, and that's why the SPU docket was opened up, and it was under several other Section 476.6 subsection 12, 476.6 subsection 12 provisions where in fact items such as long-term forecast, the procurement, these coal plants could be discussed further in a more robust, lengthier proceeding. It was ultimately closed because then what we refer to as the Wind Prime case was opened up, where the board determined that the issues overlapped with the SPU docket that had been opened up. There was consideration that the 2 cases would be consolidated, but that it would be duplicative, and that parties would have an opportunity to present evidence in that particular case.
Done? Okay, you may be seated. Thank you. I'm going to start right out of the chute asking you a question along the same line. Why not? I mean, and I actually have a really basic question, and it'll show that I do not know for sure the answers myself, but at a minimum, like an offer of proof, it's like you didn't even want to hear it. Na boo boo. Why not?
Happy to answer that, Your Honor, but let me start by saying, may it please the court. Counsel, Bret Dublinske of Frederickson Law Firm, on behalf of MidAmerican Energy and also representing the Rams of Southeast Polk High School. And I would note that my aunt, my mother's twin sister, taught until very recently at Marshalltown. So it's a pleasure to have Marshalltown in the courtroom with us today. Let me start, Your Honor, because I think it somewhat addresses that question and also goes to some of the scope questions that have come with sort of a high-level framing of where we're at and how we got here. So MidAmerican Energy has publicly announced its plans to eliminate all of its coal-fired generation by 2049. The appellants here are 3 advocacy groups who have no responsibility for running an electric system, no accountability to customers or to regulators, who think that should happen 15 years faster. And over the last several years, they have tried to force MidAmerican to have to litigate that issue in all manner of Iowa Utilities Board proceedings and in several court proceedings, often where it is not procedurally appropriate. And that's where we find ourselves today. This is an exceedingly narrow proceeding. And the board correctly held that discussion of retirement of coal plants is outside any statutory scope that's appropriate to this proceeding. So
It makes it outside the scope, Mr. Dublinske.
we could probably spend much of the day on a very, very tight parsing of this statute. No, and I would argue that
You're relying on.
the entire structure of the statute and repeated portions of it all weigh against appellant's argument here. So a couple of things. First of all, it shows up in a rate provision, and the only thing it's really about, as you were discussing previously, is whether or not rates for certain emission control equipment, or whether costs of emission control equipment get passed on to rates. The entire premise of this section is that there are, in fact, coal plants that are using emission control techniques to comply with environmental regulations, right? So eliminating coal plants actually would get you outside of the purpose of the statute entirely.
That probably this was written, you know, and this all started up around 2000, which was before, you know, an inconvenient truth and climate change was viewed, which it is now, as such an existential threat. But we still have to deal with the language of the statute. And I don't see why, in terms of your burden to show that your plan is reasonably expected to achieve cost-effective compliance with applicable state environmental requirements, which doesn't sound like a super high burden, why they shouldn't be able to introduce evidence that there's other ways to achieve more cost-effective compliance than what your client is proposing.
Your Honor, and I can go back into the details of the statutory language in a minute, but broadly let me say, I think it's clear that what the statute doesn't do is suggest that there is a buffet that people get to add entrees to and the board goes through and picks it, right? In this case, it talks about evaluating the plan or the update provided by the utility, not a suite of alternatives. And I would note that the legislature knows how to talk about alternatives when it thinks that's an important part.
Vote on the plan that you've proposed, but it's still cost-effective implies some kind of alternative. If, you know, my son in college says, I've found a really cost-effective housing option for next semester, I'd say, well, you know, compared to what? Yeah.
And I think that the details here matter. I might take a slightly different position than the board did with respect to Justice McDonald's question, and that is, I think if someone came in and said, you know, they're proposing scrubber X, for comparison, scrubber Y would cost less, but that's not what happened here. What we have as the case here is coming in and saying, board, you ought to consider making them retire coal plants because we think it's more effective, both in cost, we think it's more effective in emission controls. First of all, MidAmerican disagrees about whether that is effective on cost and disagrees whether that should be the only factor. But the bigger issue here is that, you know, I understand, Your Honor, that you were suggesting Mr. Mandelbaum understood that this didn't require the least cost or the most effective. I disagree. I heard him up here talking about optimum solutions, least cost, most effective. That is clearly not what the statute is about.
In the past, we know that retirement of coal plants has been a cost-effective option because the utilities have actually presented it themselves or agreed in settlements to do that. So if that's true, how how can that be outside the scope of the statute?
What is being evaluated here is the plan that's put forward, not a plan that somebody else put forward. And to, again, this is not about retiring coal at all. What you have is a situation where the appellants want the board, want the court, want MidAmerican to do more, right? And not just look at what is reasonable. Look at what MidAmerican submits and say, is this reasonably cost-effective way to meet your environmental compliance requirements? Which you can do without considering the retirement of coal.
Look, we're not going to consider an alternative plan. This is not picking plan A or plan B, but at least we can consider this evidence in making the determination on whether plan A, as proposed, is cost-effective.
My question, by the way, which kind of leads into that, why not? Why not? What are you so afraid of hearing or want? And I also kind of wanted, you made a comment, 15 years plaintiffs are pushing you to move faster than you have to. Well, 15 years might be a hot second in the life of a lawyer. We all know that. But in the life of an environmental position, that's a lifetime. So I guess, and wouldn't that be awesome if you guys could do it sooner than 15 years?
We're not waiting until 2049 to shut them all down. That's when the last one will be shut down. It actually starts much sooner than that. And in fact, we have been reducing the use of coal in the fleet for some time now.
That Justice McDonald asked, why not?
I mean, because relevance is a thing, Your Honor, right?
Dad, because I said so. I mean, we can't find it in the statute. It's because you said so. But that's not good enough. Why not?
The statute. And I think there are two provisions that are extremely telling here. One, 476.6A4, which specifically carves out the right for DNR to recommend amendments, and even then only on one issue, environmental compliance. Nobody disputes that this plan is compliant. In fact, I think it's interesting, there were no new capital costs included here, which is part of why this discussion of, let's talk about retirement, which they've been trying to shove into every hearing they can, is not appropriate here, right? They're trying to litigate something that is well beyond the scope, well beyond the relevance established by the statute, which doesn't talk about most effective, least cost, doesn't talk about retirements. In fact, the contrary. If you look specifically at Section F, the intent of the General Assembly is that the board may limit expenditures and investments of the company that until the time that the benefit that would be created is required by state or federal law. It is clear that the legislature has said it doesn't have to be the most effective. This isn't just about emissions.
Us to just believe you because you said it, because you're saying it's the most cost-effective way, then and nobody else gets to talk about that?
Most cost-effective. We're saying it's a reasonably cost-effective way in light of the balance.
We're just supposed to, or the board is to just take your word for it?
Be not cost-effective when we have no capital expenditures in this plan. All we have are operations and maintenance for things that were already approved and never appealed. They can't collaterally attack those expenses now. There are no new capital. Honestly, if MidAmerican can...
Point you haven't mentioned, obviously, is your client is a regulated utility. You get to pass on your expenses plus a reasonable rate of return onto the consumers of Iowa. And so, given all that and that overhanging factor, why can't the board consider, and why can't the environmental groups present evidence that there would be win-win solutions that would be more environmentally friendly and more cost-effective?
May I respond?
Answer mine.
We only get the rate of return on capital, and again, that's not the issue here. But again, and the court's familiar with this, relevance is a limit of proceedings of all kinds. And the problem is the environmental interveners keep wanting to force the litigation of coal retirement in all kinds of places that are not appropriate. And they continue to take these extremely limited proceedings and want to move them out of what they're supposed to be into their particular agenda, where they don't have to worry about reliability, they don't have to worry about the next polar vortex, right? And they want to try and and gin this issue up anywhere they can. And, Your Honor, the court should not be a party to their advocacy strategy.
By let the evidence be heard and let that be decided. I kind of feel like in a courtroom situation, I would have said, let it in. You're not before a jury. You don't have to worry about unringing that bell. Let it in. And I kind of am also wondering how much time and energy has been spent having this conversation today, as opposed to just plain letting them put that there before the board and weighing, as someone said, instead of striking. Once again, why not?
Because it takes the focus of the hearing off of the plan that's in front of the board and lets them convert it into a litigated proceeding about the retirement of coal plants.
I would say, thank you, Mr. Plaintiffs, for presenting that evidence. I'm not going to give it any weight.
And had the board done that, perhaps we wouldn't be here, but that doesn't rise to the level of reversible error when all the board had to do was look at what MidAmerica put in front of them, say this is reasonable, as they had done on almost identical support for years and years and years in the past, right? There was nothing novel about this plan. The support, the description were all virtually identical to plans that had been approved in the past. There's no reason to believe the board couldn't look at what was in front of them, use their expertise, use their past history, and say this is a reasonable approach, particularly because there's no new capital costs.
Interpretation of the statute supported broadly by the West Virginia case and the major questions doctrine. If the legislature wanted total shutdown of coal plants to be part of the mix here, wouldn't they have said so?
Absolutely correct, Your Honor, and we do talk about that in the brief, so it wasn't a priority for my limited time. But I think West Virginia, while not binding on this court, is instructive in a couple of ways. Setting aside whether or not Iowa has sort of a similar major questions doctrine, West Virginia actually follows very closely on cases where you all sort of got there first, right? So Brackey versus Iowa DNR, to your point, Justice Mansfield, about, well, isn't there a better way? Well, in Brackey, this court said even if we think there's a better way, that's still the legislator's prerogative to take up and reflect in the statute. It's like the traffic camera cases, it's like Rylea and the DOT enforcement cases, where everyone sort of had to stay in their lane and agency scope is very narrow. Second, that case happens to be instructive because factually it's extremely similar to this. The EPA did in that case basically what the environmental interveners are asking the board to do here and asking the court to force the board to do. And they want to use this 19th of 21 provisions in a rate statute to get to the issue of retirement of coal. As the Supreme Court said, it is extremely unlikely that if the legislature wanted to empower an agency to take up eliminating coal as a fuel, that's where they would hide it, right? And that's true here as well, Your Honor. Thank you.
I'll begin my reply where Mr. Dublinske left off, and that's the major question doctrine and this idea that it's not procedurally appropriate in this context. And what is going on here, we're not asking for a new statute or a new policy. The legislature has adopted a statute that looks entirely at coal plant emissions. That statute incorporates and requires compliance with state and federal requirements and standards that cover a wide array of pollutants. So if EPA in West Virginia versus EPA has said, okay, coal plant retirements are not within the scope, or greenhouse gas emissions in that specific case, Congress went back and in the Inflation Reduction Act included specific authorizing language. This statute is broad enough to accommodate changes in federal environmental requirement. It's already written in. In addition, this statute has previously been used by the utilities with the approval of the board to retire coal plants in compliance with the existing federal statutes.
putting aside the fact that they have done that themselves in the past, if the current plan does not include any new equipment, how can actually retiring the plant make the plan that's not even adding any equipment, only covering operating costs, be not cost effective?
So this goes to the evidence that we presented. And the argument that we made was the operation and maintenance costs of these uneconomic coal plants was sufficiently high, so high that other alternatives would save money. Just retiring and avoiding that operation and maintenance cost, it is cheaper to do that and replace it with renewables. That was the evidence that we presented. Now that is our burden, our evidence in the case. We have to demonstrate that. We have to demonstrate the cost effectiveness, the environmental requirements, the economic development potential, and the reliability. And we provided testimony on all four of those factors. And that is...
Show that your plan was optimal, or just show that their plan was not cost effective?
I think it showed both. It showed that, I mean, the issue is their plan. It showed that their plan is not...
To kind of the questions from the first time that you're up about whether or not the statute requires the most cost effective, and you say it does not, but then you keep talking about that by showing that there is a more cost effective plan, that makes their plan is not cost effective. So that sounds an awful lot like you're saying that if there's a better plan, then the board has to go with the least cost.
That's where the balancing comes in. We acknowledge there are four factors. There's the cost, the environmental requirement, the economic development potential, and the reliability. And we presented testimony on all those factors. The utilities have, in their plans, have treated, just like you've said, sort of the least cost as the cost effective. And that is certainly a way to meet the cost effectiveness requirement under the statute, but it is not necessarily the only way. And so we want to acknowledge that there are other factors to balance and other evidence to weigh, but certainly least cost is not prohibited by the statute. And that is exactly what the utilities did and MidAmerican did in complying with the MATS standard, the mercury and air toxic standard, in their 2014.
Alternatives involved shutting down the coal plants in favor of wind or solar. Why not natural gas conversion or nuclear?
Those are alternatives that could be weighed and could be in a different record, but that is not what the environmental parties have focused on. We've focused on not just maximizing cost, but also maximizing environmental benefit. We accomplish both of those.
476.619F gives the board the power to limit investments or expenditures that are proposed to be undertaken prior to the time that the environmental benefit to be produced by the investment or expenditure would be required. There's no balancing requirement there, as there is earlier in that section under section C. Under section A. What are we to make of that? In other words, there seems to be a fair bit of power granted to the board in section F that might sort of have the ability to undo the power that they were granted in subsection A. So where does F play into this?
Again, that's something that the board can weigh based on the evidence that is presented. Is the cost and is the benefit sufficiently tenuous? So, for example, this is a dynamic area where technology continues to improve, and alternatives that may not have been cost effective. It's partly why you have that 2 years in the statute as well. Alternatives that may not have been cost effective 2 years, 4 years ago, as costs come down, those alternatives may be more effective, and the board may exercise its discretion and think things could could change, and it's worth waiting. But it's, again, a weighing in the context of the evidence that is presented.
Opposing counsel makes an argument that this is really sort of a relevance question, and whether this evidence was relevant to what the board needed to take up here. And 17A.1910N is abuse of discretion. And evidentiary issues, we typically give a pretty heavy dose of leeway to district courts on, or to fact finders on, I guess, in terms of striking evidence, rejecting evidence as being not relevant. How does that review standard play in here?
So even if there was a deferential review here, what the board has done is irrational and illogical and unjustifiable. So the board is creating a scope of the statute that means one thing when the utility presents evidence, and it means something else when other parties, environmental parties, present evidence of the same type. The statute can't change what is within the scope depending on who presents the evidence or depending on which plan or update is in front of the board. The statute means the same thing from party to party, from case to case. And the board's interpretation creates a statute that means something different in those circumstances. And that's an absurd result that would not pass muster even under a deferential review.
And this is not a Plan A or Plan B type statute. The board either votes up or down on the plan that's presented by MidAmerican. Is that right?
The board does not, yes, it's either approve or disapprove the plan is what the statute says.
The legal injury under 17A20 that your client has suffered that should cause us to go ahead and remand this. So if we were to remand it, it's still an up or down on the plan. The board has no authority to approve some other plan that someone else created. So what legal rights of your party have been injured in a way that requires redress?
Environmental parties are party to this case, and we're party to the case to represent the environmental interests. That's the basis of our intervention, the fact that there is injury from additional and unnecessary pollution, and a plan that is approved without weighing this evidence is going to lead to unnecessary pollution.
But there's no alternative plan. It's either yes or no on this plan. The board can accept your plan. So what is the injury? I mean, I don't understand.
There's no alternative plan, but it provides a very significant incentive for the utility to address this. Because as Justice Mansfield pointed out,
Denies the plan, then what happens?
MidAmerican is taking a risk that they might not be able to recover costs of pursuing the status quo. The board is indicating that
Remain the same, right? It's the cost issue. You just said that. So everything is the status quo. They don't get to recover the costs because the board didn't approve the plan. What's changed in the universe for your client on remand? I don't see an injury.
Again, my client doesn't get to present evidence, doesn't get to address these issues and move.
You were denied the opportunity to present evidence that the board doesn't have to accept. But in terms of what happens in the real world, it's either up or down denial of the plan and nothing changes if there's denial.
On the result, and that goes to the weighing of the evidence that is yet to happen. And that's the piece that is important. We're injured with the result of just the approval of a plan in this case, but we didn't get to present evidence to even get to that question.
Mr. Mandelbaum. All right, you have 3 organizations, so it's a question of organizational standing, right? And then you have members in those organizations that I assume include real human beings that live in Iowa. And those real human beings want to pay less for energy and they want an improved environment. Is that right? And so the position is that those real human beings would be better off with this plan being defeated and MidAmerican being forced to come back and propose an alternative plan that would be better for the alternative environment and cost less.
That is correct. Okay. Thank you.
Should have reserved time for rebuttal.
You've got it. You've got it. You ask for it, yeah.
You know.
Thank you. The case of Environmental Law and Policy Center and others is hereby submitted. We'll take just 5 minutes. We're not going to leave the bench, but time for the attorneys to switch out for the next case. Next case will be McCoy versus Cardella and Associates.